VAT mechanisms require that all transactions in the chain must be tracked, short of which there will be revenue leakages as a result of fraudulent refunds and gross misstatement. The laws of Uganda do not prohibit buying items in cash. The essence of tax credits is that the VAT was suffered by the taxpayer. The proposed amendment in clause 4 defeats logic, specifically where a proper tax invoice has been issued and VAT properly accounted for. It is also notable that denial of input tax credit on the basis of a cash purchase is intended to criminalize cash payments. It's not legitimate to force all taxpayers to use banks even when cash payments are legal. Clause 5 introduces Section 30A to provide for a due date for payment of tax. Clause 5.3, Mr. Speaker, introduces Section 30A3, which is to the effect that the tax payable is due and recoverable in spite of the filing of a notice of appeal, and may be recovered notwithstanding that objection or appeal. This provision is not justifiable and equitable. The Tax Appeals Tribunal Act provides for 30% of the tax due to be paid before filing an objection or appeal. This provision is sufficient, fair, and equitable, and should therefore be enforced instead of proposing another provision under the VAT Act. 4. VAT is being exempted on the supply of tourism arrangement services, access to tourist sites, tour guides, and game driving services under the second schedule of the Principal Act. However, the tourism sector, which is one of the major foreign exchange earners for the country, requires various government support in terms of infrastructure, in terms of roads, in terms of airports, tourism roads, security, among others. The sector is already benefiting from VAT exemption on hotel facilities. This exemption should therefore not be granted so that the tourism sector can contribute to the services it requires from government. Mr. Speaker, the committee recommends that the Value-Added Tax Amendment Bill 2017 be passed into law subject to the proposed amendments. Mr. Speaker, I would like to lay on the table a copy of the original report by the committee, duly signed by over the required numbers of members who are supposed to sign the report. Also, Mr. Speaker, we have attached the minutes which we used, the minutes of the proceedings during the consideration of the bill, together with other relevant documentation that the committee scrutinized. Mr. Speaker, I beg to lay on the table.
Let the records capture that. Honorable members, in the public gallery this afternoon, we have pupils and students from Manga Child Development Center, Busia District. They are represented by Honorable Julius Maganda and Honorable Jane Nabulindo Uowa. They have come to observe the proceedings. Please join me in welcoming them. You're very welcome. Honorable members, the same principles apply. This justification for this bill, which constitutes its principles, is that they are revenue bills or money bills that are supposed to facilitate the budget. proposed a question for debate, but I would propose that we go and deal with the actual provision of the bill instead of debating principles which are already obvious given what we are doing at the moment, the budget. So can I put the question that we deal with the specifics of the provisions? I put the question that the bill entitled, I put the question to the motion that the bill entitled the Value Added Tax Amendment Bill 2017 be read the second time. I put the question. Will those in favor say to the contrary? No. The ayes have it.
Bills Committee stage.
The title.
The Value Added Tax Amendment Act 2017.
No, please. The Value Added Tax Amendment.
The Value Added Tax Amendment Bill 2017.
Bills Committee stage.
The Value Added Tax Amendment Bill 2017. Clause 1.
Clause 1, I put the question that clause 1 stands part of the bill. Will those in favor say to the contrary? No. The ayes have it.
Clause 2.
Clause 2, Chair.
Clause 2, Mr. Chairman, we propose to insert a new subclause 8 immediately after subclause 7 as follows. Under subsection 7, aid-funded project means 1. A project financed under a grant agreement between foreign government, its agency, or any other donor and the government of Uganda. Or 2. A project financed by a loan agreement between an external financier and the government of Uganda. Our justification, Mr. Chairman, is to clearly define aid-funded project to avoid ambiguity as to what constitutes aid-funded project under subsection 7.
Thank you. It's clear. Budadiri, West.
Mr. Chairman, what they are trying to do here, government, is to ensure that there is no budget for VAT on projects which are donor funded or whatever. But what is the government? Government is the one which levies tax and is the one which collects. But government cannot pay tax to itself. Now, one of the reasons why many of the contracts have got problems is that, I'll give a simple example. And the contractor does a road. He bills government 10 billion. VAT on it is at 18%, 1.8 billion. When that contractor files a return to URA, the law says he must remit 1.8 billion. And yet, government has not paid that contractor. URA will come, slap interest, and the contractor, because of interest, maybe goes to the bank and borrows. And when he borrows, at the end, when the government pays after 1 year or 2 years, they will never pay VAT with that interest, and then the person borrowed. Now, what we want to ensure here, which will help government, is that all government contracts should be zero rated. The justification is to avoid contractors being stressed to go and borrow to fund the government when government is supposed to do its own activities. What will help is that the contractors will claim their VAT and there will be no stress. URA will not put interest and whatever on these contractors. Many of the contractors have collapsed because of that. So, Mr. Chairman, the committee has gone to me. I want to make a more amendment that instead of looking at only donor or government-funded projects, it should be that all government contracts, which instead of saying is it exempt, they are saying it will be deemed to have paid. In short, they have not paid, which good English in tax would be zero rated. So they could say all contracts of government shall be zero rated.
Chair, Minister.
Mr. Chairman, I am looking at the objects of the bill, and one of them is to exempt aid-funded projects, and 2 is to provide for operations under which VAT is deemed to have been paid in respect of petroleum operations and aid-funded projects. Whereas the proposal by Honorable Mafavi is correct, my view is that it should apply where it is stated that VAT is deemed to have been paid. My view is that we replace deemed to have been paid with 0 rated because they are the same.
That's very good, Mr. Chairman. That's a good step. Deemed to have been paid when they have not paid is 0 rated. That's very good. The next one we're pushing on is that if I want to give an example, I have been given a road to do. I'm a contractor doing from Kabale to Chisoro. For it, it is being funded by government of Uganda. It means me, I must pay VAT. Kakoza has been given a road from Kinkiki, was it Nani to Kabula. For him, it is done by donors, okay, by World Bank alone. For him, it is 0 rated. So why it's the same government, and when I pay the 18%, the government must, in effect, pay me that 18%. But the problem is, it will take long for me. But for Honorable Kakoza, who has been given a donor-funded project, for him, he doesn't need to bother. He doesn't need to go to the bank. Instead, for him, it is taken as 0 rated. So it is unfair. What we're trying to say is that let us make it equitable, whether it is from donors, whether from local funds, but as long as the government funding, it is should be 0 rated. What you are doing, what the government does, is pulling money from this pocket and putting it in this what? This pocket. There's no difference. There's same value, what we call zero-sum game. In fact, government doesn't pay taxes. It doesn't. It is just a book entry.
Yes, honorable members, we are going to engage in a debate. But the provision in 2, what is proposed in subclause 7 of which section is that? I don't know. Section 24. The way it is framed, if you frame it that for purpose of this section, the tax payable, you cannot then go and say it is 0 rated. You cannot go and say it is 0 rated if it is tax payable. The way it is framed in this clause, it had better be left the way it is, unless it's going to be changed completely. Because the tax is already payable. It is now, the exemption is in the deeming that is already paid. So the way it is framed in 7, it's okay, unless you want to introduce something new. Because if you want to use the language of 0 rating, then I think that you have to redraft the whole thing and still achieve the same thing. Why go through the yes, Ntengero?
Yeah, Mr. Chairman, whereas I may want to support his proposal, there's a very big risk of revenue loss, which we need to study. According to a quick calculation, we are likely to lose over 2 trillion shillings. And this is not something that we can accommodate just so easily like that. I want to propose that we leave the proposal as proposed, and the Honorable Nandalazima Favi's proposal could be subjected to further study and scrutiny. For now, it is difficult to accommodate.
Mr. Chairman, there's no way you will lose tax with what I'm bringing. What I'm suggesting, what you are saying, government must budget for 2 trillion to pay for VAT for their goods. We are saying, no, you don't need to budget for that money now. Because it's just a book entry. It's about government. There's no loss. Please, Amos, I thought you are an economist, you understand it. So what I want to put is that there is no loss, because when a contractor does a road of government, he will build it VAT inclusive. And if he's going to pay VAT, it is government which is paying that VAT, and that VAT which is paying my Minister of Works or UNRWA has been budgeted as VAT to be paid. Are you getting it? So it is a double, it's what? A contra entry. Here your budget is as income, here you budget it as expenditure. Negative plus positive equals 0.
Let me take Butaleja first, then.
Thank you, Mr. Chair. Mr. Chair, I think I will concur with the Honorable Nandala, because the money we are paying contractors is the same money we are going to collect. We are not even sure whether when we pay 100, we shall collect 100. But the problem is that most of our engineers, the estimates will remain high. It's like a taxi, Mr. Chair. When the price of fuel goes high, when it reduces, they will never reduce the what? The fare. So it should be warned with the contractors and the ministers responsible. But the issue of paying people, again we collect. I think we should let it be 0 tax. I want to thank you.
Yes, Chair.
Thank you, Mr. Chairperson. Mr. Chairperson, under the VAT law, we have 3 categories. We have the standard rate, where the rate is 18%. We have the 0 rate, where the tax payable is at the rate of 0, and we have exempt. And Mr. Chairperson, eventually after passing this law, the application will translate into schedules. We've got 3 schedules. No, there are 2. We have got a schedule for 0 rating, which is schedule 3, and schedule 2 for exempt, and then we have the standard surprise. It is important, Mr. Chairman, before we take a decision, we get a further clarification from the ministry. If they are in the disagreement with Honorable Mafavi's proposal, where in the 3 schedules, where this proposal will fit. So unless you want to exempt, otherwise if you say it is deemed to have been paid, automatically you will make an amendment in the 3rd schedule of 0 rating. So we need to understand where...
But the whole question is, why don't you just amend the 3rd schedule? If that is what is meant to be achieved, why don't you amend the 3rd schedule instead of amending the provision of the law to come to bring this debate? Yes.
Mr. Chairman, that's what the chairman of the committee has raised is very vital. What we usually do in most cases is that, because this one I said 0 rated, and that's what the schedule means. Where there is exempt, to say, they will say, this is exempt. In some of the sections, it's clearly saying exempt. Now here we could not get the exact schedule, exact name. That's why we had to propose 0 rated. Because unless, when they say means 0 rated, then because the purpose they want to do that is that the contractor should be able to claim VAT, input VAT on his, input. on his inputs, he should be able to claim VAT to avoid the contract being too expensive. So that's what they're trying to aim at.
Honorable Minister.
Thank you very much, Mr. Chairman. Mr. Chairman, we have always engaged with Honorable Mafabi as a senior legislator. He knows the problems of moving a serious amendment on the floor of the House without any consultation. When we have been here, we were caucusing in the corridor together, and we thought we had agreed on all issues. Now he's bringing in an amendment that's very, very, very problematic. Friends, you can't think about an amendment of this nature on the floor of the House. Because, Mr. Chairman, we'll have a problem if you say that we zero rate the VAT. What will happen to the taxpayers' VAT input? They will claim all of it. You see? So I wanted to suggest, Mr. Chairman, that we could move on other amendments, and then we allow Honorable Mafabi to interact with us, and then we come up with a harmonized position. Because this is very, very, very dangerous for us, Mr. Chairman. As the chairperson of the budget has said.
Honorable members, clause 7. What is wrong with clause 7? I mean, not clause 7, the subsection 7, which is an amendment in section 24 of the Act. What is wrong with the drafting in the bill? Yes, this 7, which is under 2. What is wrong with it, really? No. What is wrong with this clause 7? I mean, subsection 7 of section 24, which is being proposed in the bill. What is wrong with it?
Mr. Chairman, I'm sure the ministry or government, not the ministry, is saying that contractors who come in to do contracts in Uganda, it's because of VAT that they get a problem. And they want to say that those projects now, government is supposed to, which has been paying anyway, and because it delays to pay, it's saying to avoid that problem now, let us say assume it is, which would be deemed to have paid, so that these contractors can claim their VAT on input. And this will make the contract cheaper. That's what they're trying to achieve. So, in short, they want a road to be done. That's why the committee went further to say a road to be done at a cheaper price. Because VAT makes the road high, and at the same time, the delay to pay. This is what they are trying to achieve. So the argument which we are saying, we should not look at only donor projects. Now the committee has gone further to say even those with loan agreements, like the loans you pass in Parliament should fall in that. Now I said that this one we are now being selective. Now those who will use the money from the budget of Uganda doing the same work, for them they will suffer. While those who are using money from out will not what? Suffer. And yet this one will suffer twice. Government delays to pay, yet he goes to the bank and borrow and pays for VAT. Mr. Speaker.
Information senior.
Okay, Mr.
Mr. Chairman and honorable colleagues, one of the problems which actually we discussed here yesterday was the issue of counterpart funding. You said we go and borrow and we don't have money to do counterpart funding. And because of this, loans have not been performing. And this has been a situation. You go out to borrow money, say a contract will take 500 million shillings. If you add VAT, it comes to close to 560 million. A lender or a donor said, no, we are not going to be responsible for the 60 of VAT. We are going to give you the 500. And therefore, you must budget what we call counterpart funding for that extra 60. So what we are saying is that let us assume that it has been paid. It is deemed that we are paid and exempt it. That's why we are particularly talking about donor-funded projects. But if you want to open it up for all government projects, it's a discussion that cannot be concluded in 5 minutes here.
So, Mr. Chairman, now the minister has become very clear. He is saying for donor funded, because the money is borrowed, they must not pay VAT, but the government deemed to be paid. Now for a local one, which also will come under appropriate, there's no difference in this money, by the way. The other one is coming from out, borrowed with interest. This one you are collecting from taxpayers, but you are going to do the same thing. Road A, road B. Now we're saying, it is the same idea, the same principle. It's the reason why you delay to pay on government, on donor projects, is the same reason you delay to pay on locally funded contracts. That's it. Now, why do you? Because the VAT you're talking, you're pulling it from this pocket and taking it this pocket. There's nothing that you'll lose. It's even, you're an accountant, you know what I'm saying. Okay, you add.
Just to say something also. When we talk about the donor projects being exempted, for instance, if we are talking about that, the person who is doing a contract will not be able to claim for what? For VAT. And that will be a problem. And that's why we are saying this should be at a zero rate. They should be zero rated so that somebody can be able to claim tax, the VAT on the inputs that somebody is even buying locally from Uganda here. If you are buying something from the Ugandan market, for instance, you have to pay VAT. If we say exempt because of the donor funding, then the contractor cannot claim for the what? The VAT, and that will be a problem. So I think this one needs some time, and then we discuss first so that we come up with a proper answer to this. Otherwise, we shall make it in a wrong way. Thank you.
Honorable members,
Mr. Chairman,
conclude. Let me do this. Let's look at what the committee has proposed as a definition to what this would mean. Once we finish with that, then we come to this an amendment. So there's an amendment proposed by the committee to define what aid-funded project means. Is that okay? Can we take a decision on that? So that it is explained, it is clear. You don't begin bringing anything and saying it is also aid-funded. Because we have skills on making things apply to everything. So for the avoidance of doubt, the committee is proposing that a new sub-clause 8 be introduced to provide specifically for a definition. Is that okay?
No, but Mr. Chairman, maybe that's not okay for me as yet.
Yes?
Mr. Chairman, the reason we are saying, even
No, Honorable Mafobi, what you are saying is okay, but here we are only defining what you mean by donor-aided project. That's what you are defining, not whether it should be exempted or not. All you are saying is what you are calling donor-aided project should have a definition, a clear definition. That's all. So then, whether you are going to use it to apply it to other contractors is another matter. But now, all that is required is there a need to define the word, the aid-funded project? Yes. If it is there, then let's take that decision. Then we come back to this instead of leaving everything hanging. Okay? If there is a need, is this definition sufficient?
Mr. Chairman, just for clarification, I want to ask. First of all money which comes in, by the way, we pay it back. In most cases, we pay back the money. Like World Bank, one of the reasons is the World Bank. We borrow money to do a road. It has interest, we shall pay. In short, it is the people of Uganda who are paying, which they collect from taxes, but they have deferred the payment for a period of what? Time. That one is no different from the one you have collected this year, and you have spent it on the same project, which is in a different locality. So the reason why I'm raising this, Mr. Chairman, is that many companies are going under because unless we come up here with a law to protect the local, like for example,
Honorable Mafabi, the point I was making was very simple. Aid-funded project. Is there some animal called aid-funded project? Does that animal require definition? That is all I'm asking for now. If it requires a definition, is this definition sufficient? And member for Agago district is saying it is not.
Mr. Chairman, take it from me. Thank you, Mr. Chairman. I think it is very important to clearly define that particular provision, because when we make a law and most members don't understand well, it becomes a lacuna. So it is important that we explain what we mean by donor aid clearly in respect to the provision that we want to put in this case. Because when we say zero rating, might be a blanket statement.
No, Honorable. Have you read what the proposal made? The amendment made as a definition?
Yeah.
It is here in the report. Have you read it?
I was following it right.
No, I haven't read it, so I've not read it loud. So if you are relying on what I have said, then you have not yet read it. Can you read it first and see if it needs improvement?
Mr. Chairman, way out.
Yes.
Mr. Chairman, the way which I want to propose, if the minister wants to go and study, is that if you want these ones to be deemed to have paid, then the local ones should be on cash basis. What I mean, if I've done a contract for government, I will account for VAT when you pay me. You understand? Cash what? Cash basis. That would be the best way to go out, because now you want an exit because you don't want to lose anything, to avoid taxpayers being penalized for tax which is not theirs. So what I wanted to move, we can say A goes as the committee has amended with the loans outside. Then we create B, that all government contracts shall be accounted for VAT purposes on cash basis. Justification is to avoid taxpayers going to borrow money to pay taxes which are not theirs, or to pay interest on what is supposed to be done by government. And the Minister of Finance is aware of this. Many contractors have complained the ministry and they have even raised issues that now you have even written a letter saying you are responsible for that VAT, leave it, we shall pay, but you have not told them about the interest which has accrued. We want to do a law to protect our locals or the contractors here and to make contracts in Uganda relatively cheap than making them expensive.
Do we need, Mr. Chairman? Mr. Chairman, I think we should not, I want to beg Honorable Nandala Mafabi, who actually is a member of the Committee of Finance and agrees with the amendment of the committee to mix issues, because we are mixing issues of late payment, delayed payment, with tax procedures, with what, how those can be sorted out later. But what we're talking about is that we have been having a problem of counterpart funding. And the reason why is that we have been budgeting for this contract where we're going to borrow money, and we say the contract will take 1 million, but there is money for VAT, 1.18. What we are saying, since this is a condition to get this money, and we don't have it, and it has been a problem, why don't we exempt it? Yeah, that's what we are saying. Why should we continue suffering with counterpart funding? Eh? And that's why we are saying this is specific. But what you are saying, the government money is already, which we are budgeting, is already, it takes care of this tax and the cost. The issue of now paying on time, we handle it separately. That's the issue of accounting officers who are in discipline. They get money, they don't pay on time. That's a different issue.
Mr. Clarification,
But
Mr.
counterpart funding, can you answer that?
Yeah, I'm going to answer, Mr. Chairman.
Member of the Committee of Finance.
Yeah, Mr. Minister, thank you very much, Mr. Speaker and Mr. Minister. The VAT you give Ministry of Works to pay, it pays to URA. And it comes back to the consolidated what? Fund. You have picked 1.8 billion from the consolidated fund, taken it to URA, and asked again URA to return the 1.8 billion, the consolidated fund. That is the simple thing. No, listen, don't panic. You see the problem, you don't know you want to panic. Now, what I'm explaining is that the reason you have said you want counterpart funding, the projects are saying VAT will be paid by government of Uganda. Are you getting it? And the reason you are coming here saying we don't have to put that money in the budget because it will be cash in, cash out, the same issue, the same pocket from here to here. So you are coming here to Parliament for purposes of those contractors to say, you go and do the work, the tax is deemed to have been what? Paid. That's simple. Now what I'm trying to raise up here,
Procedure.
Procedure.
Thank you, Mr. Chairman. Is it procedurally right for the members of the Finance Committee to come on the floor of the House to start arguing as if they haven't been attending meetings and confusing everyone seated here in this August House? Is it procedurally right, Mr. Chairman? They should go back to the committee, harmonize their position, and come back and present their issues so that we can understand what they are talking about. Right now, we are not following. All the people who have been talking, Mr. Chairman, Honorable Golobi, Honorable Franca, Honorable Mafabi, the Honorable Kakoza, they are all members of the Finance Committee. Therefore, Mr. Chairman, is it procedurally right for these members to come here and confuse everyone on matters of taxation as if we are...
Honorable members, the rationale for saying that members of a particular committee who have been part of the process of bringing the matter back to Parliament should not debate was to avoid this kind of situation. Because by the time they come here, they should have agreed. And if they did not agree, they should file the reasons for their disagreement. So that you come and argue your position, say, yes, the committee said this, but we did not agree with the majority of the committee. That's why we are also saying this. So that both positions can then be looked at by the whole House. But to be in a committee where there was unanimity, and then you begin arguing as if the committee was on the other side and you are on the other side, it's a bit difficult for us to process at this stage. Because the views you are saying now, this House is not structured in a way that it could have understood the details the way a committee would have. The minister would have been there, all those technical people, URA, which is not now here, would have been there, and different people, contractors would have been there. Now they are not here. So that's what complicates this kind of situation. But that is not to say that if a new matter should arise that was not within the knowledge or could not have been looked at by the committee, it should not be brought at this stage. But this is hardly one of those things that could not have been seen by the committee.
Mr. Chairman, I want to explain. Mr. Chairman.
Please, I think we need to move.
Yeah, Mr. Chairman,
If we make a mistake today, we'll correct it in the next financial year.
Mr. Chairman,
we need to move.
I beg your indulgence.
No,
Mr.
we need to. Honorable Mafobe, I think you have spoken sufficiently
No, just
on this
indulgence
subject.
to explain my matter. Mr. Chairman, first of all, you cleared me to travel. Please listen. Please, if you cleared me to travel, and when I came back, me and the shadow minister, we raised the issues, we wrote a minority report, and it was agreed that we come and harmonize our positions here. And we spoke to the chairman, and the minister knows about this. I went personally to the speaker, if she was here, and said, we have understood this matter to be raised. I know these rules very well because I've been here longer than many of the people here. And this business of saying, yes, for you, Honorable Rakimari, you came in and you jumped out a bit, you came back. So what I'm bringing, Mr. Chairman, is to help. Because if I keep on information, even the Bible will be killing. So that's why you saw me raising all those issues. But we had talked with the chair, we had talked with the minister, and that's why the minister now has turned against me. So I've confirmed Honorable Bahati cannot keep his word from today.
Honorable members, still, please. No, please. If you had talked to them, you would have proposed an amendment in writing. Now, the fact that you have not even proposed an amendment, which the rules allow you to do, and now you are proposing it orally, we have not afforded the opportunity to examine it. As presiding officer, I like things that have been processed and interrogated properly. This one is not one of those. So we can make mistakes. Kabula.
Chair, I would like to convince Parliament to take the route you've guided, that we go step by step to avoid mistakes. If there is a need, we should define, as we amended that we should define aid-funded project. Then after agreeing with that decision, then we see the drafting of the intention of the object of the bill. I think it will make us a headway.
So is this definition sufficient? Yes. The definition for aid-funded project. I'll put the question to that amendment for introduction of new clause 8. I'll put the question. Will those in favor say to the contrary? No. The ayes have it.
Clause 2 was amended.
I now put the question that clause 2 was amended, stand part of the bill. Will those in favor say to the contrary? No. The ayes have it.
Clause 3.
Clause 3. I put the question that clause 3, yes?
Mr. Chairman, clause 3 should be deleted because it is already in the VAT Act of 2015. It is there. So, you know, so there's no need for this clause here. It is already in. It was in the VAT Act of 2015.
Do we have a text of the amendment of 2015? Please, let's be helped. I only have the original act.
Mr. Chairman, I have it here. I can lend it to you.
See, you would have been a very good resource to the committee. These matters were so important, you should not have asked for leave to travel. No, I think it goes beyond what is in this one. It goes beyond. It goes beyond what was done in 2015. Honorable Falvi, it goes beyond this.
Mr. Chairman, I'll explain.
What's in the bill goes beyond.
Yeah, what I will do, if you go ahead, what you will discover which is there is what you would have been there is 4. But if you go in 25, 4 is taken care of in the schedule. You see, the first one, A, B, C, is in the law. It's there. Now the only one which you are not seeing is the 4. But if it is the formula, it's about the formula, where they are saying it's deemed to have paid. It's there. It's covered, Mr. Chairman. He'll go through further. I can give you the schedule.
Honorable Minister. Does it cause any harm? Does it cause any inconsistency? If it does not, we adopt because it will be reinforcing what is there. But if it creates an inconsistency, then that's where the problem is.
No, Mr. Chairman, what we are proposing here, this amendment reinforces what is already in the law. And that's why it's an amendment. If you read carefully, Honorable Nandala, it's different from what is there. So there's no way that we could have brought a clause which is already in the law.
Maybe for information, Mr. Chairman, what we can do, if the minister wants to do for clarity, he can bring in 4. He deletes A, B, and says C, insert immediately after subsection 3 the following. For contract of government, that one's okay. The other ones, is, if you read, Mr. Chairman, read the text of A, is there, of B is there, the only one you can bring in is C.
No, B is not there. B in the bill is not in the text of that law. Because 3 is about a licensee. B is for a supplier component X. So if it does not introduce any contradiction in the law, we adopt it, and then the implementation will not have a problem. Yes, Kyoga.
Mr. Chairman, I don't think any contradiction would be introduced here because certain provisions are repeated for purposes of emphasis. And if it doesn't cause any contradiction, I think Honorable Nandala should allow us to proceed, Mr. Chairman.
Honorable members, I put the question that clause 3 stands part of the bill. Will those in favor say aye? To the contrary, no. The ayes have it.
Clause 4.
Clause 4, Chair.
Clause 4, Mr. Chairman, we propose to delete the entire clause. Our justification is that the provision defeats logic, specifically where the proper tax invoice has been issued and VAT proper accounted for. It is also notable that denial of input tax credit on the basis of a cash purchase is intended to criminalize cash payments. It is not legitimate to force all taxpayers to use banks even where cash payments are legal.
Honorable Minister, you are defeating logic. Please come and state why you want to defeat logic.
Mr. Chairman, I think the amendment was logical, but in the interest of progress, we are conceding.
Honorable members, the motion from the committee is for deletion of clause 4 in the bill. Clause 4, yes? I put the question that clause 4 be deleted. Will those in favor say to the contrary? No. The ayes have it. Deleted.
Clause 5.
Clause 5, Chair.
Clause 5, Mr. Chairperson, we propose to delete the entire clause. Our justification is that Section 15 of the Tax Appeals Tribunal Act provides for 30% of the tax due to be paid before filing an objection or appeal. Section 15 of the Act is therefore sufficient, fair, and equitable, and should therefore be enforced instead of proposing another provision under the VAT Act.
Honorable Minister.
Mr. Chairman, I want to convince the chairperson of the committee that clause 5 is very important because, Mr. Chairman, we erroneously deleted this provision in the enactment of the Tax Procedures Code last financial year, and without it, there is no other provision that will require the taxpayer to declare and pay without this provision. So it's a correction that we are making.
Mr.
Then we
Chairperson,
should have taken it back to law where he took it out from.
exactly, that is my argument. Mr. Chairperson, the Tax Procedures Code bill is next. I would like to persuade the Minister of Finance to introduce this clause, this section again, when we get to the Tax Procedures Code bill.
Honorable Minister, since we took it out of the tax procedures code,
Mr. Chairman, even in the tax procedures bill, you cannot make a law which is where we have a law already, like the tax appeals tribunal, which says 30%. Mr. Chairman, if you look at this, this is being brought in bad faith. Look at the subclause 3, where an objection or a notice of appeal against an assessment has been lodged. The tax payable under the assessment is due and payable, and may be recovered with notwithstanding that objection or appeal. It means if they assess you 1 billion, whether you're appealing or what, they will come and collect. You have appealed until that's why when you go to court, you say the status quo must stay until the court determines. Now you come and enforce, take my property, I win the case tomorrow, what happens? So that's why this one should be deleted. That's why last year it was deleted. If it is true it was there, that was the reason why it was deleted. And again it must be deleted.
Mr. Chairman and honorable colleagues, last year when we were amending the Tax Procedures Code, we erroneously deleted this clause from the VAT Act. So what we are doing now is to reinstate it. Mr. Chairman, you can see I have provided you with the volumes as a lawyer to guide us on how to proceed, but we erroneously deleted it. We are reinstating it.
no, yes, Honorable Kakoza.
I'm a member of the committee. Our argument stands that whenever you give me an assessment, if I'm a taxpayer, there are avenues where I can appeal. When I appeal, when the verdict is not made, you cannot force me to pay, because URA has all the ways to seize the goods and be in the hands of URA. But the moment you say you are seizing my goods, you've not had me, but also pay. That's what we are saying. We are saying, if I'm in appeal, please wait for me. Once the verdict comes that I should pay, I will pay. That's the essence of this bill we are saying.
Are these the same reasons they used the other time to delete it from the Act?
Mr. Chairman, they were not the reasons.
Because you are saying Parliament erroneously. This House does not act in error.
Yeah, because of the respect of the House, that's why we are bringing it back, that we put it
No, they are the reason. Now you need to restate so that the House is persuaded that it can be reintroduced, because it's the House that deleted it.
So, Mr. Chairman, can I suggest that we
Have we lived without it for a while?
Yes, we stand over this and then...
Oh, no, we're not going to stand over anything. Have we lived without this for a while? What has been the implication of saying without it?
No.
If they have not had any implication, delete, we move.
Yes, I want to
We don't
convince
have time to.
the Minister
Yes,
of Finance.
we don't have time for this
Mr. Chair, I want to convince the Minister of Finance, in all fairness, I think the Chair, you know the laws, that somebody must be heard, must be given a fair hearing. The moment you give me an assessment, and that's why in the Constitution, there is a tax tribunal. So if there is a tax tribunal, you've given me an assessment, and I've appealed against what you've assessed me, please, when the verdict comes, I will pay. But don't force me to pay before.
Honorable Minister.
Mr. Chairman, I want to put
Information from Maracha.
Thank you, Chair. We have this handout that was given to us today by the Minister. The implication of that particular provision is that we have over 800 billion, which is in court because of the delays. So I thought that's one reason why the Minister was justifying their introduction.
Mr. Chairman, when you read the proposal in 30A3, it reads, where an objection to or a notice of appeal against an assessment has been lodged, the tax payable under the assessment is due and payable, and may be recovered, notwithstanding that objection or appeal. Mr. Chairperson, the Tax Appeals Tribunal Act provides that when an appeal is lodged, the taxpayer only pays 30%. If an appeal is 1 billion, you are required to pay 300 million, and then 700 million pending the determination of the appeal. And this is what the minister's proposal is trying to defeat. And this is why the committee is insisting that the status quo, as it is in the Tax Tribunals Act, stays.
Honorable Minister, would it be proper if in clause 3, so that we move, in clause 3, instead of making it the way it is, you cross-reference the tax tribunal code, that provision, so that when this situation arises, that is what applies. That you don't have two regimes. One law is saying 30%, one law is saying the whole thing is payable. By cross-reference, that where an objection to a note to or a notice of appeal against an assessment has been lodged, the tax payable shall be handled under the provision of the tax procedure, the tax appeals law. If it is there.
It's there.
Yeah, you cross-reference. You can leave the whole provision, but then in 3, reference to the call the provision of in the tax appeals law to apply. So that you don't have two regimes. One saying 30%, one saying the whole thing. You can consult on that.
Mr. Chairman, even further.
Yes.
Mr. Chairman, if you read number 1A, in the case of a taxable supply by a taxable person, in respect of a tax period, on the date of the return for the tax period must be lodged. What is the meaning here? If I lodge in my return, I lodged in my return in 2010, and URA assesses me now, but I've paid my tax there, they are saying that if they get an additional tax of 1 million, it will mean that that tax should have been paid in 2010, and now they will compute it with interest if you pass it in this way. You see, this looks silent, but it's very dangerous. Why? If you are
which provision is this? Which provision?
You just read 31 due date of payment. It's this one. If you look at it, tax interest in the tax period 1A. Indirectly, it's talking about the tax period.
I think the problem, Chair, I think the problem is the issue of the 30%. Because I'm understanding. Possibly we need to remove the 30%, but keep the issue of the due date. When the date is or the due date for paying the tax. But the 30% should be removed. If that can help, we leave the issue of the due date.
The objection is on assessment. Yes. You've given it to me. I have a tax liability. If I have a tax liability, I've gone to tax tribunal. The notice is lodged. The case is not heard. But you are forcing me to pay before even I'm heard. Even that's why a tax tribunal is saying, even if you have a tax liability, pay 30% first. But if we say I pay it all, suppose the verdict comes. So I must be heard if I'm appealing against the assessment you've given me. That's the line, the bottom line.
Chairperson, Honorable Kosa, I think we're on the same page. Because once we have the 30% under the tax appeals tribunal, which has no contention. But to introduce it in this one is what I'm saying. We should only be able to leave the due date. Because the due date of paying the tax, like for VAT, is on 15th.
Yeah, but you see, no, the due date which I'm saying here, Mr. Chairman and colleagues, they are saying due date for payment of tax. 1, the tax payable under this tax is due and payable. You're getting me. Any due and payable, now I want you to notice that. In the case of a taxable supply by a taxable person, in respect of a tax period, on the date the return for the tax period must be logged. You get me? Now, the logging, you log your tax return on 30th December 2010. URA comes and raises an additional assessment. That's why you see they're running down to bring 3. Then they raise additional assessment. They will say that tax is due on 30th December 2010. Now, if they have assessed you today, they will compute all the interest from that day to this. What it is saying, URA can sit on your return even if for 10 years, they will assess you, and they will assess you with interest anytime they come up. We want to protect taxpayers. In fact, what should be here is that you, when you log in your return, you must pay tax on the due date. If there's an additional assessment, it must be paid when you raise the additional assessment. That's what we're trying to see. So what the Minister of Finance wants to do is he wants to amend this so that when they raise it today, they say, but you are supposed to have paid it in 2010. So this is the law. That's why you look at it, it looks silent, but it's a very dangerous bad law.
No, but Honorable Mafavi, you are talking about 30 capital A, 1A. And the last sentence, the last phrase in that, say, on the date the return for the tax period must be lodged. Because if you don't lodge it by the date of that day, you have already violated the law. You have taken away the protection of the law from yourself. Yes. So you are not protected by the law because you have already violated it. Yes. So why are you saying the assessment should not take that period when you should have lodged? Is there any justification for that?
Chair, that's why we are saying, since there is a Tribunal Act, which says that the moment they give me an assessment, I can appeal. We can be consistent with that one, instead of saying, to which is proposed in this bill, and in 3, where an objection of notice of appeal against an assessment has been lodged, the tax payable under the assessment is due and payable and may be recovered notwithstanding the objection of the appeal. That's why we are saying, if the Tax Tribunal Act says, if you assess me, I paid 30%, the assessment you've given me, I've gone to the tax tribunal. Let me pay that one. The assessment I am appealing against, we wait for the verdict from the tax tribunal to be consistent.
Because what Honorable Fabi is saying is now different from that. It's now on A. and it's saying you should not be paid interest if on the date, if for example, you are supposed to have filed your returns today by law, but you did not, and you are now being assessed 5 years later.
Mr. Chairman, I want to make the correction.
Yes.
The assessment schedule, the assessment is under assessments, and under the VAT is section 32. It clearly shows when you are supposed to file the return and the due dates. And it says when you fail to file, you will be penalized. I want you to get me that, Mr. Chairman.
Yes.
Now, here in this case, I have filed the return. If you go through that's why they bring the objection. I have filed the return on the due date. I have paid the taxes. I am up to date, according to me. URA comes after 7 years. It says there's an additional assessment. There's an addition, that's why you see the appeals. So it says additional assessment, 1 million. This assessment additional is in respect to the return of 2010. So now the due date is the date when the return was lodged. So now my 1 million, which I should have paid now, they are assessing me with interest. So that's because there's no, in this law 32, Mr. Chairman, it's covered about returns. What is this? What they are bringing here indirectly is now to justify why they should charge somebody interest from 2010. That's the basic, but the lodging is here. In the main law, Mr. Chairman, the date of return is clear. If you don't file, you will have a problem. If you file a wrong return, there are penalties here. The time and the place, there's a time for amendments. All these are here.
Yes, so now there are two issues being raised. One, which is in 3, for being payable, the whole thing payable. Maybe the minister can speak on that, then we'll deal with this new issue. There are 2 issues now. One is in 3, subclause 3, and the one now in 1A.
No, it's even up to C.
Yes?
Up to C, Mr. Chairman, up to C, because if you read the first one, then they go to B. Now, in the case of the assessment as issued under this act, on that day specified in the notes of assessment, have you seen the notes of assessment? They will issue an assessment saying the notes of assessment show that the tax due is due on 20th of 20th December 2010. That's the notes of assessment, and there you are. Then it says, in any other case, the date the taxable transaction occurs as determined under this act. So what they're trying to say, Mr. Chairman, is that URA can take its time without assessing you, and it comes tomorrow and it says you have got additional assessment and you must pay it with interest. When you raise an appeal, they say no, you must, and now you go to Syria, you must pay it whether you are under appeal or objection. That's the purpose why that is. No.
Now, Honorable Minister, if the due date is already in the law,
It's there.
which provision is there? If it is already there, then why are we bringing it here in 3A?
Mr. Chairman, I don't know which law he's referring to, but
VAT law, which
section?
Which section?
I have the VAT law here, 32, assessment.
Yeah.
I can read it verbatim. They say under section 32 is assessments, where 1, a person fails to lodge a return under subsection 31. Section 31 says, a taxable person shall lodge a tax return with the Commissioner General for each a tax period within 50 days after the end of the period.
15.
Yes. Yes.
It is 15. The law says 15. It doesn't
Yes,
matter what you
that's
say.
15th day, that's what the law says. That means the date you file on your return is known within the law.
Mr. Chairman, first we wanted to deal with the issue of the amendment by the chairperson of the committee.
No, but now the whole clause is in issue.
Yes, the issue was the chairman of the committee says why he wants to delete this clause is because the Tax Tribunal Act covers it. What the Tax Tribunal covers is when you have a person who has a dispute, the law requires you to deposit 30% of the value of the dispute that you have. It is a different issue that we are talking about. That's when I thought we should clear it. But on the issue of clause 3, which is becoming problematic, I wanted to, because the rest of 3A shows you the due date when you should actually be paying the tax. And it's nowhere in the law that we have cross-checked. But clause 3 of the, rather section 3 of the clause, we agree that, Mr. Chairman, we can delete it. And then we move on the rest of the clauses.
No, in clause 5, there's that provision of 30 capital A. And there's 1, 2, 3, 4, 5. He's now proposing to delete 3, which say the tax will, the tax payable under the assessment is due and payable and may be recovered notwithstanding that objection or appeal. That's what is now proposing to be deleted.
But Mr. Chairman, that's the reason why actually we are bringing it back, because last year the Tax Procedures Code repealed section 32 of the VAT. So that's why we are bringing it back. And that's why we said the House in its wisdom deleted it. And we are saying let's reinstate it. Yes.
Are you saying section 32 was deleted?
No. Chair, I don't want the
Mr. Chairman,
minister.
that's why I said we could do probably first cross-check. I had brought the volumes near you, but we could be given 5 minutes and we first
section 32
cross-check.
is the assessment.
The Tax Procedures Code.
We are, Chairman, Minister of Finance, I don't know whether he has really made his homework. Our argument, why we internalize that and we say we should do, the moment I'm given a fair hearing, I will pay when I want. But when I'm not given a fair hearing, I will not pay. And most of the cases, businessmen who have put in money, they need to be heard after the enforcement of the assessment of the appeal.
But Mr. Chairman, what Honorable Kakoza is saying, your argument is that this is already covered in the law. And we are telling you that last year, when we were legislating on the Tax Procedures Code, we deleted them and we are just reinstating. So there's no contradiction.
Information, Mr. Chairman, I've been around again. People don't want to hear my being around. Now we have here the assessments. Of course, it has been amended in the law. Under 32(7), it is clear stating.
Honorable Mafabi, it is that 32 which has been entirely deleted.
No, this is a law.
Yeah, it was deleted by the tax tribunal, the tax procedures law. Last financial year. I have it here. The following provisions of the Value Added Tax Act are repealed. A, Part 8, Sections 31, 32, and 33. B, Sections 33A to 40. C, Sections 46 to 64. Is this true?
No, but Mr. Chairman,
It was deleted by this.
no,
So those sections were deleted. But the question then, why don't you reinstate it in the terms it was in the law? Why don't you reinstate it in the terms it was in the act or the one they're reading?
But Chairperson, I had a suggestion that what is critical for us is to look at the real spirit of what we are talking about. If somebody is appealing against the tax, our issue is there should be a charge so that not everybody should just run and say that that tax is not fair to me. People will find a problem handling that issue. So the best thing is we have to maintain that, yes, that the charge that we are talking of the 30%. But let us look at the implication. If the tax, the Tribunals Act is talking about 30%, and then we have the 100%, do they contradict? What is the implication of the two? We studied the two thoroughly, and we understand, and we come up with the right thing. Thank you.
Mr. Chairman, I want to ask a clarification again from the minister. If he says that was deleted, why have we been filing returns on 15th? What law have we been using? 2, if you think we deleted 32 wrongly, why don't you reinstate 32? Because it clearly shows everything, even the appeal procedures, the tax time periods, fraud. Why don't you reinstate that? Rather than bringing in a new thing, did you delete it so that you bring new things? Because the other one worked from 1996 up to 2016, as if you say we deleted last year. That was 10 years or 20 years, I don't know. Now, what's the problem?
Chair?
Mr. Chairman, we've listened to the arguments by members, and our prayer is that if the objective is to reinstate what was deleted in the previous financial year, then, but Mr. Chairman, I am in doubt whether it is true that we deleted this clause, this section. I'm in doubt, because if it is true that we deleted, why do we still follow the same procedures when we are filing returns? I am in doubt. However, if the objective is to reinstate the original position, then we go back to the original position as it is, and as it were before, without introducing further amendments.
Procedure from Dogolo.
Mr. Chairman. Mr. Chairman, I'm rising on procedural matter. I'm very concerned the way the debates is going on. Many of us are not members of the Finance Committee, and we trust members of the Finance Committee that they will digest some of the issues which are very technical, which cannot be debated in the House, and then come to us with a version that we can all understand. Mr. Chairman, however, I'm now seeing that the chairman of the committee doesn't seem to be in agreement with even the Ministry of Finance. And even within themselves, the committee doesn't seem to be in harmony. So I think, right, Mr. Chair, procedurally, I would plead that the chairman, that you chairman give permission to the committee to harmonize itself and come up with a position, and also to try and give us a version with the speaker, with the minister, so that when they come here, they come to explain and to persuade us to agree with them. But right now, the more they debate, the more we are getting confused, the more we don't know whether to go with the committee or to go with the speaker, or to go with the minister. Right, Honorable Speaker, who is the chairman of this session, can you save us? Some of us who are not members of this committee. Thank you.
Chairman, clause 5 be deleted. Is that your proposal?
Yes, Mr. Chairman, I must state categorically that as a committee we are harmonized. And we do stand by our proposal to delete the entire clause.
I put the question to the deletion of clause 5, the entire clause. Can I put the question? Yes. Honorable Minister, I am putting the question and I expect you to vote. I put the question that clause 5 be deleted from the bill. Will those in favor say aye? To the contrary, no. The ayes have it.
Clause 6.
Clause 6, Chair. There is no amendment. Clause 6.
Mr. Chairman, clause 6 is talking about interest. My thinking is that many taxpayers are not paying taxes because of interest. Here they're saying we waive up to a certain portion. My proposal here is that in section 65A2, we waive all the interest and ask taxpayers to pay the principal. The reason is we have done it, we did it in 2007, yes. We did it in 2009, and the reason why many people are not having a problem is only interest. And it would be better, we say we waive the early interest and people pay the principal tax. The justification were not here waiving the principal. One was saying, this interest is becoming too much for bad times, business is collapsing, go free.
Mr. Chairman.
Minister?
Yeah, Mr. Chairman, while we have been defeated on the previous one, but this one I think it's important that Honorable Mafabi, really, if you want to make an amendment, because we are now on the committee stage, you make an amendment and give justification so that the House makes a decision with information, with knowledge. But if you are going to debate, then you are amending by way of debating. That's what we do at the second reading, where we are just debating. But now, given the fact that he was absent, and we don't know where he was, and then he comes with these amendments, really. Should we really take them like this? So what is the amendment you are proposing?
Mr. Chairman,
so that
Mr. Chairman, first, 65(1) is okay. We have agreed, Mr. Honorable Minister. But 2, we're saying that the interest due as of 30th June 2017 on taxpayers be waived. The justification is that we want to allow taxpayers to pay their principal the amount so that we say start again afresh. This one we have done it. We did it in 2007. We have done it in 2009. And with a long time we have not done it. And even you have seen the economic situation is so bad. Many people, houses are appearing in newspapers for sale because they must sell and they get interest. That's what we're saying. But the other one why I agreed is that from now on, the interest to be computed should not exceed the principal sum and the penal tax. That one from now, it applies. But for now, we request that interest, and we tell them that you must pay this tax by 30th of June 2017, and you'll get all the money.
Chair.
Mr. Chairman, in 2, if I may read, for avoidance of doubt, where the interest due and payable as at 30th June 2017 exceeds the aggregate referred to in subsection 1, the interest in excess of the aggregate shall be waived. So where is the problem?
Can I put the question? But there's no amendment, so.
No, Mr. Chairman, I think what the amendment is, if you have known, it is saying the interest in excess. What they are saying, if you are supposed to pay 1 million and they have access to you interest of 1.5, you will only pay equal to 1 million. So you will pay only 2 million. It's 500, which is waived. We are saying no, for purposes of taxpayers, let us waive the whole interest of 1.5. And this is what the law is saying here. So what I'm saying, for avoidance of that, where the interest is due and payable as at 30th June 2017 is hereby waived. That's the amendment I'm doing, Mr. Chairman.
What is the justification for that?
The justification, Mr. Chairman, is that we have waived even principal tax, by the way. In the law of 2009, we waived even principal tax.
Are we doing it just because of that, or there is a better reason?
No, I'm coming, Mr. Chairman. In 2007, there was a waiving of interest. Now, the justification I'm saying, the tax, we're not waiving the tax. The tax is due. But what we're saying, hard times are here. Even we as we're speaking now, Mr. Chairman, we are in hard situations. We're saying, you taxpayer, you pay the principal, but the interest is waived. Even the banks, by they are waiving interest now. So, Mr. Chairman, the justification is to give relief to taxpayers so that they can use this money and reinvest, make more money so that we can tax.
Mr. Chair.
Buvuma?
Thank you very much, Mr. Chair. To me, I think the law can't work retrospective. If we begin now, it means onwards, but not backward, because it may put government into a situation that may not be understandable. I thank you.
True. True.
Thank you, Nathan.
So I put the question. There's an amendment that has been proposed by the Honorable Nandala Mafabi to delete clause 2, subclause.
I'm not waiving, I'm not deleting clause 2, Mr. Chairman. Subclause 1 said the interest due and payable on unpaid tax shall not exceed the aggregate of the principal and the penal tax in one. That one, so we're saying that from now on, that's why my sister from Ovuma is saying, from now on, if you are supposed to pay 1 million as tax, then they say interest computed on 1 million is 1.5 million. They will remove the 500, you will pay 1 million. That will be 1 plus 1, that's 2 million with interest. That's one, clause 1. Now, the second one is saying they are waiving now the excess of the 1 million now. Now I'm saying, for avoidance of doubt, the interest due and payable on 30th June 2017 is waived. The justification I've explained, but the principal tax must be paid by 30th June. So that people pay, if you don't pay by June, we reinstate.
Okay, honorable members, are we there? Can I put a question to that amendment? I put the question to amendment proposed by the honorable. No, it has been proposed. Can I put the question to that amendment? Will those in favor of the amendment proposed by the honorable Mafabi, will those in favor say aye? To the contrary, no? Aye. The noes have it.
Clause 7.
Clause 7. Mr. Chairman, we propose to amend clause 7 as follows. Under paragraph SC, replace the entire paragraph with the following. SC, the supply of deep cycle batteries, composite lanterns, and raw materials for the manufacture of deep cycle batteries and composite lanterns. The justification, Mr. Chairman, is to promote renewable energy sector. Under paragraph C, delete subparagraph SD, and our justification is that the tourism sector, which is one of the major foreign exchange earners for the country, requires government support in terms of good infrastructure, roads, airports, tourism roads, security, among others. The sector is already benefiting from VAT exemption on hotel facilities. This exemption should therefore not be granted so that tourism sector can contribute to the services it requires from government.
Honourable Member, just
Insert,
Uh-huh.
I'm still
Okay,
continuing.
okay, proceed.
We further propose to insert a new paragraph SF as follows. The supply of agricultural insurance premium or policy. The justification, Mr. Chair, is to support the agricultural sector.
Thank you, Chair. Just to be sure, did I propose the question? Did I put the question on clause 6? Did we take a decision on clause 6? No. Can I put the question on clause 6? I now put the question that clause 6 stands part of the bill. Will those in favor say aye? To the contrary, no.
Aye.
The ayes have it. Clause 7, the amendments have been proposed by the Chair. Can I hear from the Minister?
Mr. Chairman, the spirit of this amendment is to promote tourism in our country. And we think as many tourists come to the country, the more revenue that we'll earn. One of the research that we did, what we found out in the region, for example, they have removed VAT on such services. We are saying if a tourist comes to our country, just to access a tourist site, remove the 18%, get more tourists and get more revenue. That's the logic of this. And it has proved that it works in TZ, it has worked in Kenya, it has worked in Mauritius, everywhere it has worked. So, Mr. Chairman, the argument of the chairperson that this will actually reduce our revenue, to the contrary, it will increase our revenue by getting more tourists in the country. And this is backed by research. The committee's suggestion is needs to be rejected by the House.
Can I give information?
Information, Chair.
Can I give information?
Information, Chair.
Let me first say this, Honorable Kakos, through you, Mr. Chairperson. Mr. Chairperson, this idea of hiding into what our neighbors are doing to mislead the House is not a good practice. Mr. Chairperson, when we amended the VAT Act to provide for an exemption on hotel facilities, we were deceived that our neighbors were not charging this VAT. After the amendment, I personally traveled to Arusha, and I went to a national park called Ngorongoro National Park. I asked in this hotel whether their bill included VAT, and I established that whereas the argument here was that in the region there is no VAT, it was misleading, and actually these hotels were charging VAT. So, Mr. Chairman, as we debate this, I would like to invite the House to put this into context.
Mr. Chairman,
Chair.
Contrary to what the Chair is saying, we have actually seen, and this information was supplied to the committee friends, that when we got out to the VAT on accommodation, we saw a sharp rise in a number of tourists coming from 250 to 350. And by the way, we are not only talking about foreigners coming to our sites, we're also talking about local people. You coming to Guinea, impenetrable forest to watch the gorillas, you should not pay tax. That's the suggestion we're saying. And as many people go there, there are other fees that we are charging here and there, and you make more revenue. Friends, this is from scientific research. It's not just hearsay, and we should really take this into consideration.
Chair,
Thank you,
I
Chair.
don't. Chair,
Chair, I think the scientific research of the Honorable Minister now agrees with what he opposed for soft drinks. Yes, that is the principle. Because with soft drinks, he said it is not all right to remove or to reduce the tax. It would actually take away some billion from 13 to 10. Yet in this one, he is now saying the contrary. That's scientific what? Research. So please, you really need to be consistent. So now, on this one...
On the other one, it did not have scientific research. This one...
But that principle applies. But right now, I would like to also agree with him. Since we are still going slow in trying to promote tourism. Yeah, it's okay to not tax, to exempt, not to tax those people very much. So even us, when we go for tourism,
information.
we should not be taxed
Information.
very much.
Information.
So I agree with the minister. I support the proposal of the minister. Thank you.
Information. Chair, I would like to convince Parliament. Some of us have been in these hotels, like Mwea.
No, please give information.
The information I want to give. The infrastructure development of government with contribution is so huge that somebody coming from a foreign state, he cannot fail to pay for a guide. This is as simple as that. If you say that somebody wants to get access to infrastructure which government has put up and you don't want to pay for it, go in USA. You sleep in a hotel, you must pay for that services provided by government. So somebody coming from USA going to Mwea and you fail to pay for the services of a guide when government has provided a road, electricity, every infrastructure, where will you get money to do that? It beats the meaning. That's why the committee we sat and agreed and said, no, if somebody wants a service, you must contribute for it. Can you go in the park without money?
Mr. Chairman, there is an argument here which the minister argued that when we terminated the VAT of 18%, so many tourists came to Uganda. I would like to ask him to provide information to the House. No evidence on whether the hotel accommodation charges reduced as the result of exempting. They instead increased. So it is not true that the taxation alone can promote tourism. Information, you can. Shadow Minister, information.
Mr. Chairman, there are many reasons that have to be in place for us to attract tourists in this country. And in my own observation, the government has not yet done enough on the most critical issues when you compare with our neighbors. For instance, a person coming to view gorillas, the mountain gorillas in this impenetrable forest, windy, requires a minimum of 3 days to get there. In Rwanda, they have already constructed an aerodrome very near the mountain gorillas. So it only takes a day for a tourist going to Rwanda and view the gorillas the same day and gets back. In Uganda, it has to be 3 days. In other words, what I'm saying is that the minimum requirements that we need to address have not been addressed before we begin talking about taxes. I don't think that this exemption is going to cause miracles until we have addressed those minimum requirements. So the timing is wrong.
Information. Mr. Chairman, yesterday the Honorable Speaker said that where he visited, that government appointed a minister for happiness and positivity. I've been seeing a spirit of happiness and positivity in this house, and I don't want to be the one to really disturb it. So I want to concede that we move forward.
Honorable members, the committee has proposed amendments to clause 7 of the bill. I put the question to those amendments. All those in favor say to the contrary, no. The ayes have it.
Clause 7 as amended.
I now put the question that clause 7 as amended stands part of the bill. All those in favor say to the contrary, no. The ayes have it.
Title.
I put the question that the title of the bill remains as the title to this bill. All those in favor say to the contrary, no. The ayes have it.
Motion for the House to resume.
Honorable Minister.
Mr. Chairman, I beg to move that the House do resume and the Committee of the Whole House reports thereto.
Honorable members, the motion is for resumption of the House to enable the Committee of the Whole House report. I put the question to that motion. Will those in favor say to the contrary, no? The ayes have it.
Report from the Committee of the Whole House.
Honorable Minister.
Mr. Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Value Added Tax Amendment Bill 2017 and passed it with amendments.
Motion for adoption of the report from the Committee of the Whole House.
Honorable Minister.
Mr. Speaker and honorable colleagues, I beg to move that the report from the Committee of the Whole House be adopted.
Honorable members, the motion is for adoption of the report of the Committee of the Whole House. I put the question to that motion. Will those in favor say to the contrary, no? The ayes have it.
Bill third reading.
Honorable Minister.
Mr. Speaker, I beg to move that the bill entitled the Value Added Tax Amendment Bill 2017 be read the third time and do pass.
Honorable members, the motion is that the bill entitled the Value Added Tax Amendment Bill 2017 be read the third time and do pass. I put the question to that motion. Will those in favor say to the contrary, no? The ayes have it.
The Value Added Tax Amendment Act 2017.
Congratulations, Honorable Minister. Congratulations, honorable members. It's been a tough one, but we've pulled it through. Let the ministry look at all those things that need to be looked at again, do proper research, and come back to the House next.
Bill second reading, the Tax Procedures Code Amendment Bill 2017.
Honorable members, can we put it at committee stage, then we proceed for, then tomorrow we just deal with the clauses. Yeah, just receive it. It won't take long. Please, members, we've come this far. We can do a little more, 5 minutes.
Yeah.
No, this is just receiving the report.
I beg to move that the bill entitled the Tax Procedures Code Amendment Bill 2017 be read the second time.
Is the motion seconded? It's seconded by member for Kitgum District, member for Tororo District, member for Kaberamaido County, member for Gomba. Would you like to speak to your motion briefly?
Mr. Speaker, in brief, the amendment is to provide for provisional tax estimates to be furnished after every 3 months, provide for due dates for filing returns under the Lotteries and Gaming Act, to provide for the penal tax for failure to provide documents in respect of transfer pricing, and provide for tax stamps and other related matters. I beg to move.
Honorable members, the motion is, which I propose for your debate, is that the Tax Procedures Code Amendment Bill 2017 be read the second time. That's the motion, and this matter was referred to the committee. Can the committee report to kick off debate? Briefly.
Thank you, Mr. Speaker. Mr. Speaker, the committee considered the bill entitled Tax Procedures Code Amendment Bill 2017 and made the following observations. 1. The bill requires persons dealing in goods, whether local or imported, to affix stamps. This will legalize tax stamps and put in place mechanisms to allow for their operation. The stamps will help minimize under declaration of goods by both importers and local dealers. The bill also gives the Commissioner General powers to prescribe the manner in which these tax stamps shall be applied. The security features entailed in the tax stamps will allow for verification, monitoring, and tracing of goods. 2. Clause 5 of the bill seeks to introduce a penal tax of Uganda shillings 50 million for failure to provide records requested by the Commissioner in respect to transfer pricing within 30 days of the request. This provision is redundant due to the fact that the Tax Procedures Code Act 2014 already has provisions that cater for this. Section 15 of the Tax Procedures Code Act requires taxpayers to have in place records required to determine the taxpayer's liability under the tax law or enable the taxpayer's liability to be readily ascertained. Section 29 imposes a penalty of double tax payable on a person who deliberately fails to maintain proper records. Section 55 of the Tax Procedures Code Act also makes it an offense for a person to fail to comply with the requirement to furnish information requested by the Uganda Revenue Authority in a notice in writing and on conviction. On conviction, such person is liable to a fine not exceeding 25 currency points. The proposed amendment seeks to impose an additional requirement on taxpayers to maintain transfer pricing records, which are not defined in the proposed amendment. The committee recommends that clause 5 of the bill, clause 5 should be deleted. Mr. Speaker, the committee recommends that the Tax Procedures Code Amendment Bill 2017 be passed into law subject to the proposed amendments. Mr. Speaker, I beg to report. Mr. Speaker, I beg to lay on the table the copy of the original report by the committee, duly signed by the minimum required members. Also, I beg to lay on the table the minutes of the committee capturing the proceedings during the scrutinizing of the bill, together with the materials the committee used in processing this bill. I beg to lay on the table, Mr. Speaker.
Thank you, Chair. Honorable members, using the same procedure we have used for the two previous bills, on the principles of the bill? Yes, yes.
I know I want to request something. Mr. Speaker, the principles are good. This bill is too short. And as you pleaded with members, I wanted to plead with the members' indulgence. There are only two clauses. It will take us 2 minutes, we're done. And this one I've agreed. Why don't we deal with it? And we'll wait tomorrow to deal with another law. That's what I was trying to propose, Mr. Chairman.
Thank you, honorable members. The proposal is that we see if we can deal with this because we have two more bills remaining and all these reports and the time is not there, honorable members. Can we see how far we can go with this? Honorable members, in the spirit, can I put the question to the motion? I put the question to the motion that the Tax Procedures Code Amendment Bill 2017 be read the second time. Will those in favor say to the contrary? No. The ayes have it.
Bills Committee stage.
No, you haven't read the title.
The Tax Procedures Code Amendment Bill 2017. Bills Committee stage. The Tax Procedures Code Amendment Bill 2017, Clause 1.
I put the question that Clause 1 stands part of the bill. Will those in favor say to the contrary? No. The ayes have it.
Clause 2.
Clause 2.
Clause 2, Mr. Chairman, we propose to replace the entire clause with the following. The Tax Procedures Code Act 2014, in this act referred to as the Principal Act, is amended in section 16.8 by substituting for paragraph C the following. A provisional taxpayer's estimate shall be in the form prescribed by the Commissioner and shall be furnished to the Commissioner by the due date for the payment of the first installment of provisional tax for the year of income. Justification, Mr. Chairman, is to allow the Commissioner to prescribe the format for furnishing the taxpayers' estimates.
Honorable Minister.
Mr. Chairman, I agree with the chairperson.
Honorable members, I put the question to that amendment proposed by the chair of the committee and agreed to by the minister. All those in favor say to the contrary, no. The ayes have it.
Clause 2 as amended.
I now put the question that Clause 2 as amended stands part of the bill. Will those in favor say to the contrary, no. The ayes have it.
Clause 3.
I put the question that Clause 3 stands part of the bill. Will those in favor say to the contrary, no. The ayes have it.
Clause 4.
I put the question that Clause 4 stands part of the bill. Will those in favor say to the contrary, no. The ayes have it.
Clause 5.
Clause 5, Chair.
Clause 5, Mr. Chairman, we propose to delete the entire clause. Justification, Mr. Chairman, is that this provision is redundant. The Tax Procedures Code Act 2014 has provisions that provide for this. In A, Section 15 of the Tax Procedures Code requires taxpayers to have in place records required to determine the taxpayer's liability under the tax law or enable the taxpayer's liability to be readily ascertained. Section 49 imposes a penalty of double tax payable on a person who deliberately fails to maintain proper records. Section 55 of the Tax Procedures Code Act also makes it an offense for a person who fails to comply with the requirement to furnish information requested by the Uganda Revenue Authority. In a notice in writing and on conviction, such a person is liable to a fine not exceeding 25 currency points. The proposed amendment seeks to impose an additional requirement on taxpayers to maintain transfer pricing records, which are not defined in the proposed amendment.
Honorable Minister. Proposal is to delete, and the reasons are clear.
Mr. Chairman, the reasons why we had put this was to cater for especially the multinationals who have different companies in different companies. And we thought, we still believe that this provision can help us collect this difficulty that we have been having to catch these people who are not declaring in time. And as Honorable Nandala, we discussed this issue with him, and he knows really the problems that we are facing in this area. So I wanted to propose that we maintain this bill, this clause, to be part of the bill.
Okay, Mr. Chairman, I think as always, there are no records which are different from other records as far as transfer pricing is concerned. You see, transfer pricing is that you make a company in a country A, maybe it produces goods at a certain X value, because you want to transfer taxes in that area, you either overprice them so that here in Uganda you make a loss, or you undercut them so that you will pay less taxes here on entry. That's the purpose. So these records exist. So, Mr. Chairman, there is no reason we should maintain this. We want making URA inefficient. They want to become inefficient. They should do their work. They must have investigation if they are suspecting transfer pricing. We must train staff if they don't have them in transfer pricing. And world over, there's already a department for transfer pricing. So this law is quite redundant, because the law says you must produce any record anytime if it is demanded by URA. Failure to do it, you are penalized. So why are you bringing this, Mr. Chairman?
Honorable Minister.
This should be deleted. And I'm talking as an accountant now.
But Mr. Person, if you read it, a person who, upon request by the Commissioner, fails to provide records in respect of transfer pricing within 30 days after the request is liable to a penal tax equivalent to 50 million shillings. So all we are saying is that if we request this information and you refuse, you fail to submit it within 30 days, be punished somehow.
Information, Minister, information. The information I want to give you, there is nobody where will differentiate that I will keep a record that this is a record about transfer pricing, this is a record about accounts. No, it is the same record, the same information.
But the justification, Honorable Member, is saying that in section 49, it is provided for. In the
You
same
can
law.
take the documents anytime you want.
Yes, that's what is in the justification from the committee.
And you can separate the documents.
And they are saying it is what? For double taxation, is it? Will penalty of double tax payable on a person who deliberately fails to maintain proper records of.
Mr. Chairman, unless the minister wants to defeat our justification, I see no reason why you should not concede.
(49), Honorable Minister. Honorable members, that there are two principles here. The first one is where you fail to maintain record. That is what is it 49. But what is being proposed is where you, on request you refuse. Is it? A person who, upon request by the commissioner, fails to provide records in respect of transfer pricing, blah, blah, blah. So, yes, Kasilo.
But Chairman, just like Honorable Nandala stated, there are no separate records. He uses the same records that we are using. And under the law, there are sanctions, there are penalties for not keeping proper records. There are penalties for if you falsify records, or if you decide to keep 2 sets or 3 sets of records in order to evade taxes. There are sanctions, there are penalties for that. So I don't see the reason why the minister is saying we should have a separate thing. Yet we are using the same records. There are no separate records for transfer pricing. They are not there. It's the same record that you use for financial statements.
Suppose it is this way. A person who, upon request by the commissioner, fails to provide records within 30 days after the request is liable to a penal tax equivalent to 50 million shillings. If you remove the issue of, in respect of transfer pricing, because this is now on request and is giving a time frame of 30 days. Would it be reinforcing?
Mr. Chairman, that's the whole purpose, transfer pricing. That MTN has its books of accounts here. They are also operating another branch somewhere else. They in Kenya or in India. Now, as the Commissioner General of URA, they submit records. I look at them. But I say I want more records regarding Kenya or India. They are not kept here. Yes, that's why you can't say why, because sometimes they have been giving us wrong information. That's the whole problem. So we are saying if we ask for that information, friends, the clause is saying if the Commissioner General of URA requests and you refuse to submit in 30 days, if you are requested to submit and you refuse, now if they are available, why would you not submit them? So we are saying if you refuse or don't submit it in 30 days, we are going to penalize you.
Don't we have a law for failing to provide records to a revenue officer or to the Commissioner General? Don't we have? I just want to, and it's an offense under the Act for non-failure to produce records.
Okay, Honorable Members, let's put it this way. What damage does this clause bring? What conflict is there that this thing is going to bring?
Mr. Chairman, I want to...
Can I start from this side?
Okay, fine.
Mr. Chairman, if this is going to help enhance tax administration, I think let's support it. I don't see us losing anything.
Is there any conflict?
And it's not in conflict. You know, it only enhances. So let's have it.
Is it in conflict with any provision?
Mr. Chairman, it is.
Yes.
Because who determines transfer pricing? Not a taxpayer. I can be involved in an activity assuming it's at arm's length. Let me give an example of transfer pricing. All the information is available. It is up to URA or whatever say, no, this item is transfer pricing. Let me give an example. I form a company in Kenya. I form another one in Tanzania, another one in Rwanda. So the one of Kenya manufactures. It invoices the one in Tanzania. The one of Tanzania invoices the one in Rwanda. The one of Rwanda invoices the one in Uganda. Now when it comes here, the goods are at a higher what? Cost. So now, in short, I have distributed my profits in those countries because maybe those tax rates are lower. That's what we are looking at. Now, what is the rationale? There is what we call HS codes and whatever, this international pricing. You would know that a phone called Nokia On the price in the market, it is $100. Why is it in Uganda, you are costing it $120? This now you will say no, there must be your company, you're transferring the $20, that's why you're doing that. And that's URA which will determine. How will you get it? You say, I want all your accounts. The law says you must get the accounts. All your invoices, all your suppliers, they will give you. Then it will be you to cross-check with other tax regimes in other countries to be able to find out if these people are declaring XY. So, Mr. Chairman, if you bring that law and make it, it will mean, even mean, and if I delay to give the Commissioner General returns, I must pay 50 million. So what we have to do, the law exists already, which covers anybody who doesn't furnish the Commissioner General with document. One, you will be penalized double the tax. Two, they will compute interest from when you are supposed, because that is fraud. And the moment it's fraud, the tax is 100%, penalty is 100%.
Honorable Minister, is there a limitation on the kind of documents you can request that this provision now seeks to introduce?
No, it's the limitation that is there is records regarding transfer pricing. And I think Honorable Nandala has made it. He has said, if the Commissioner General says, I want records over this invoice, that is what we are saying. I'm requesting you. You have declared this. I just want extra information on transfer pricing.
So
give it to me. If you don't give it to me in 30
would you
days,
not be able to do that without this provision?
you cannot.
How?
In existing law, we have failed. That's why we have brought this one.
Mr. Chairman, transfer pricing has been around us for some time. It is not a new phenomenon that is beginning to arise in our tax administration. Therefore, it is not true that there are no current mechanisms upon which information relating to transfer pricing can be got. Mr. Chairperson, I am of a strong opinion that there are other mechanisms within the existing tax administration frameworks for accessing records on transfer pricing. Information?
Honorable members, I want to put the question.
Mr. Chair.
No, I want to put the question. Yes.
Before you put a question, friends, I wanted, Chairperson, I want to really request the House. We have been pleading here that we need to increase our revenue to GDP ratio. And one of the reasons we have been failing is tax administration. We are telling you that this measure will enhance our tax administration and collect more. I don't know, just a second, I will give you 1 minute, just 1 minute. I don't see why Honorable Nandala and the chair can now say, we are saying this provision is not harmful to the current law. It only enhances the capacity and capability of URA to collect more money. Yes. We lose nothing, we actually gain a lot.
Can I give
information?
Thank you. Honorable Minister, I will give you information in form of asking you a question. Are you aware that in such circumstances under the current law, Commissioner General is given the powers where a taxpayer fails to provide records to estimate? If you fail to provide, they estimate the tax, and if you fail to disprove that, you must pay. So that's just the remedy which is there with people who fail to produce records. I don't know whether he's getting it. Because that's what is provided in the law. Failure to provide, they estimate.
Honorable Minister,
and you will see a taxpayer running. The law provides that if you fail to provide records, the Commissioner General estimates the tax, and you will see a taxpayer running with the document.
It's provided for.
Where? Which?
In the law.
No, which? Mr. Chairman, which law is it?
Mr. Chairman, I want to quote two laws, whereby the Commissioner General has the authority to estimate a tax if you fail to file a return. Under returns section, furnishing of returns, section 92. 92, if under 92, there are due dates for filing returns. And it says, that's how it goes, 92, 93, 94 assessment. And this clear says, where a taxpayer fails to file a return or to provide the information, the Commissioner General has the authority to estimate.
You were not reading, you read.
No. This is a law, Mr. Chairman. This is a commissioner. Listen. The commissioner, where the commissioner has made under this, and the commission shall include assessment as the reason why the commissioner was not satisfied with the return. And this is how it comes. I want the commissioner, a taxpayer, this is a law, why do you lay it on table? That where the taxpayer defaults in furnishing a return of income for a year of income, or the commissioner is not satisfied with it, that's 95, with a return of income for a year of income, that's furnished by the taxpayer, the commissioner may, according to the commissioner's best judgment, make an assessment of chargeable income of that taxpayer and the taxpayer thereon for the year. Number 3, where the commissioner has made an assessment under section 2B, the commissioner shall include with assessment a statement of reason as to why the commissioner was not satisfied with the return.
I want to ask Honorable Mafabi which provision, which section of the law you are reading, because there are sections that we repealed last year.
It doesn't, Mr. Chairman, this is the assessment, well, we may have changed them, but this is according to the law, which has not been appealed because this is what is section of Act 2006, section 95. And if you want to read them very well, you start from 92 returns.
Which law is that?
The income tax law. Everything, Mr. Chairman, the the procedures is trying to tax people according to the laws, either under the VAT, under the income tax, under the customs, under the excise.
Mr. Chairman, we can check the repeals that we made last year under the tax.
Honorable Minister, if they are repealed, under what law?
What section was it?
Honorable Minister. Honorable Minister.
Yes?
Yeah, Chairman, I was asking the minister if he says they were repealed. Honorable Minister, I hope you are listening. If you are saying we repeal, then under what law does the commissioner operate for those other taxpayers who fail to produce records? Can you tell us which law?
That's why we are here, Honorable Elijah.
You are talking of transfer pricing.
Mr. Chairman.
Mr. Speaker, permit me to ask, does it apply only to, Chair, permit me to find out or to seek clarification as whether it applies to ordinary taxpayers or to multinationals. Isn't it to multinationals?
Chair. Chair, I think we couldn't lay on this. Chair, I don't need that. Why we put it in that amendment and we made it, then what is the practice? If today you present an invoice to URA of the goods of a company you know you bought, if they are not satisfied with your values, they will not pass it. Why? Because they have got prior information that the country where the goods are coming from, their tariffs, their codes, the price is known. It's incumbent upon the investigating capacity of URA to say the price, the invoice you forwarded to us are wrong and they assess you. And the practice is not all values on the invoices presented by URA, they accept them. No, they investigate them and give you the correct assessment.
Yes, Honorable Member for Tenjiro South.
North.
North.
Mr. Chairman, the former president of South Africa, Thabo Mbeki, was requested by the African Union to undertake a study on financial illicit flows. And it was established that over a period of about 5 years, Africa had lost a total of $7.8 trillion in illicit flows, especially on account of multinationals. Mr. Chairman, you are aware that even here locally, we have been struggling to get information from the likes of these telecommunication companies on phones that terminate in other jurisdictions. And we have also been complaining about a problem of enhanced tax administration as a major source of raising our revenue. And here we are. URA is coming to us saying the current regime, legal regime that we have is not sufficient for us to enforce this requirement. I think it is a very polite request. And we are not losing anything. Unless some of us have interest, we have failed to declare. It is a very polite request. Why don't we accept this request? You know, because it enhances tax administration. And we have been crying for this enhanced tax administration. We want to reduce these financial, illicit flows.
Clarification. Clarification, Amos. Clarification. Yeah, thank you very much for giving way. The clarification I want to seek. The URA is authorized to audit anybody, anytime. And you wanted this document, I'm sure you want to audit it. You want to audit it. What bars URA to say, we want to audit you next week, and we want the following documents? What bars? It's the law.
Honorable members, I think we need to do this. It is true that provision of the Income Tax Act were repealed. It is also true that sections of the value-added tax law was repealed. But it was repealed for purposes of creating a procedure within one law. It was not removed because nobody wanted them. Because in this case, what was repealed in the in the Income Tax Act is now brought under Section 18 of the Tax Revenue Code Act. Power of the commissioner to inquire tax returns in certain cases. This section applies if during a tax period, A, a taxpayer has died, B, a taxpayer has become bankrupt and wound up, C, a taxpayer is about to leave Uganda permanently, D, the commissioner otherwise considers it appropriate. The commissioner may, by notice in writing and at any time during the tax period, require the taxpayer or the taxpayer's representative to furnish a tax return for the period by the date specified in the notice, being a date that may be before the date that the return for the tax period would otherwise be due, or B, the taxpayer or taxpayer's representative to pay any tax due under the return. And in 3, where a taxpayer is subject to more than one tax, this section applies to each tax separately. Then 19 is extension of time to furnish a tax return. And then from 20 is tax assessments.
So,
and under assessment, there is self-assessment, there's default assessment, there is advanced assessment.
So, Mr. Chairman, you have read the law.
So the question that I asked at the beginning, which I am now asking again, and we need to conclude this, is does this particular new provision that is being proposed, that it bring any injustice to anybody?
Yes.
How does it offend you?
How does, what kind of, yes, Buvuma?
Speaker, you said that does it offend, Right Honorable Chair, you said that does it offend anybody? Yes. As someone who, it is in 2 phases. The first one is, if I want my government to earn money from the revenue, what measures, what criteria was used to establish the 25 currency points, that is 50 million as a penalty, on what amount of goods?
No, that's a different discussion.
That is for my goods.
That's a different discussion. The issue is the principle of this provision, not the penalty itself. This provision that where a commissioner, on upon request by a commissioner, fails to provide records within 30 days is liable to pay whatever is going to be paid. Is that principle wrong? If they request you for a particular set of documents and you refuse or you fail to do so within 30 days, does it cause any problem?
Yes, Mr.
Then
Speaker.
if the issue is the amount, then that can be another discussion.
Mr. Speaker, I would think that it is also wrong because if you give me 30 days to present this, and maybe I don't have those documents at that time, I assume that with this computerized system that we have in our country, no goods that pass anywhere on the border minus the consent of URA. So I would think that you give me time to present those documents that you want than just imposing a penalty on me.
So the 30 days are too short. I'm asking about the principle.
Mr. Chairman.
Where is it provided for? No. I have read the same thing and there is no direct provision like this.
Mr. Chairman, what this new amendment, what is different, what is new that this amendment is trying to bring?
Order members.
Mr. Chairman, the amendment seeks to impose an additional requirement on taxpayers to maintain transfer pricing records, which are not defined in the proposed amendment.
And I asked the question, if you remove the term transfer pricing, would it change? And the minister is saying it is the gist. Would you have to call the name for it to be done, or you have to provide for it to for the particular person now to say, I want a specific thing on transfer pricing. That would now be the content of the request. Must it be in the law? No. That transfer pricing? If the Commissioner General wants to ask a specific question about transfer pricing, then he will now ask for transfer pricing. Must you have it in the law that for transfer pricing? Or that will be a request from the Commissioner General?
Yeah, Mr. Chairman, you have stated that what Honorable Nanda read is nowhere in the law as specific as this. Now, what this provision is trying to help us, and I want to state this, that as members of parliament, it's also right that we listen to people that we have given a duty to collect tax. And they are telling us we are finding it difficult in dealing with these multinationals who are actually 80% contributors to our income tax. The multinationals are paying close to 80% of the income tax that we are receiving as a nation. And we are finding difficulties. And we are saying let us empower the commissioner with this provision to strengthen tax administration. And this provision is not harmful. We are saying it's just requesting you, can you give me more information in 30 days? And if you don't submit it, I can punish you as an incentive for people to have these requests.
No,
if
but-
you have them.
But the question is, that more, can you give me more information? Must that more information be called transfer pricing?
Mr. Chairperson, you know as a lawyer how difficult these lawyers or multinationals can make it to us. If something is not in the law and we are requesting it,
So, in
it
other
will
words,
be
if
very
you,
difficult.
if you make a request under this particular provision, which is nothing to do with transfer pricing,
yes,
you will not make that request.
we want a request on transfer pricing. And say harmless.
Okay. Can I put the question to this now? Yes. I'm going to put the question to the proposal. You have had the minister, you have had the chair of the committee. The chair of the committee is proposing that clause 5 be deleted in its entirety. The minister has presented the case that this particular provision has come from practitioners, that they have a challenge and they need to be assisted by this house to be able to deliver. So I'm now going to put the question to the committee's proposal for deletion, because that is the amendment. The minister has not proposed an amendment. So I'm going to put the question to the amendment as proposed by the committee to delete clause 5. Okay? I put the question that clause 5 be deleted. Will those in favor say aye? To the contrary, no. Honorable members, let's not try to, let's play fair. Let's vote at the same time and we take a decision. I put the question to the motion that clause 5 be deleted. I put the question. Will those in favor say aye? To the contrary, no. No. The noes have it.
Title.
So now there is no amendment in clause 5. I now put the question that clause 5 stands part of the bill. Will those in favor say aye? To the contrary, no. The ayes have it.
Title.
I put the question that the title to the bill remains the title to the bill. Will those in favor say aye? To the contrary, no. The ayes have it.
Motion for the House to resume.
Honorable Minister.
Mr. Chairman, I beg to move that the House do resume and the committee of the whole House reports thereto.
Honorable members, the motion is for resumption of the House to enable the Committee of the Whole House report. I put the question on that motion. Will those in favor say aye? To the contrary, no. The ayes have it.
Report from the Committee of the Whole House.
Minister.
Mr. Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Tax Procedures Code Amendment Bill 2017 and passed it with amendments.
Motion for adoption of the report from the Committee of the Whole House.
Honorable Minister.
Mr. Speaker, I beg to move that the report from the Committee of the Whole House be adopted.
Honorable members, the motion for adoption of the report of the Committee of the Whole House. I put the question to that motion. Will those in favor say aye? To the contrary, no. The ayes have it.
Bill third reading.
Mr. Speaker, I beg to move that the bill entitled the Tax Procedures Code Amendment Bill 2017 be read the third time and do pass.
Honorable members, I put the question to the motion that the Tax Procedures Code Amendment Bill 2017 be read the third time and do pass. I put the question to that motion. Will those in favor say aye? To the contrary, no. The ayes have it.
The Tax Procedures Code Amendment Act 2017.
Thank you. Congratulations, Honorable Minister, Chair. Thank you very much. Congratulations, Honorable Members. And thank you for staying up to this time. One announcement from the Honorable Munyagwa Mubarak. He is with deep sorrow, announces the death of his mother, who has just been buried now. But the information is for members to know and find a way of supporting him. It's already buried. Okay, honorable members, this House is adjourned to tomorrow 2 o'clock.